Hello everybody, welcome to another edition of Source Intelligence's Prop 65 webinar series. My name is Jay Sailing and I'll be moderating today's webinar. We've got a lot to jump into today and we also have some great special guest speakers, so let's take a quick look at our agenda. So I'll give a quick introduction to the speakers, go over some webinar logistics information, and then we'll jump right in. First guest, he's a very familiar face over here at Source Intelligence, Wayne Rosenbaum. He'll be speaking about Prop 65 in 2019, special industry situations, and really the future of environmental product compliance. Next, we'll have our very own Jennifer Krause speak, and she'll give us an overview of Prop 65 compliance process, supplier engagement best practices for Prop 65, data collection, data analysis, and she'll also be walking you guys through a hybrid product compliance program. And then I'll give a few closing remarks, but that should be it for today. So a little bit about our speakers. We're very excited to welcome back Wayne Rosenbaum to this event. He's been on previous webinars before and always has a lot of really good Prop 65 related information to share with us. As a little background, Mr. Rosenbaum helps clients develop and implement solutions to environmental regulations that are both legally defensible and economically sustainable. Mr. Rosenbaum also assists his clients in defending their regulatory compliance programs against challenges by regulatory agencies and environmental groups. And we also have Source Intelligence's own Dr. Jennifer Krause. Jennifer is our Chief Scientific Officer and Executive Vice President of Operations here at Source Intelligence. Dr. Krause has over 25 years of experience providing multidisciplinary strategic environmental health and safety services to her customers all over the world, really, US, Mexico, Canada, Central, and South America. Prior to co-founding Source Intelligence, Dr. Krause was president of Global Environmental Consulting Company. So just a little bit about our today's webinar. Everyone will receive PowerPoint slides from all the speakers and an entire on-demand version of the webinar. You can also find the entire presentation and past Prop 65 webinars on the webinar page of our website. And also, we got a lot of questions during the registration period. So instead of answering them after both speakers are done, we're going to give the speakers a moment to digest the questions and answer on a formal document that we'll send out to all attendees. And we'll keep you updated as to when we'll be able to publish that. So now that we have the introductions out of the way, first up is going to be Wayne Rosenbaum, and he's got a lot of really good information to share with us. So Wayne's up first.
Good morning. My name is Wayne Rosenbaum. I'm a partner with the Environmental Law Group. And today we're going to kind of pick up on highlights and updates for California's Proposition 65. This is really a follow-up webinar or presentation. About 6-8 months ago, we provided you with the basics on Prop 65 and the new Article 6 revisions. And those are available through Source Intelligence at their website, and we've provided the URL so that you can take a look at that. Today, we're going to kind of take a look at what's happened since then. And we're going to look at notices of violation, what are the trends, how are we really looking at and interpreting these new sets of regulations, and then we're going to span out a little bit and look at other associated regulations that if you are concerned about or working with Prop 65, you should also be aware of. So far, or since January of 2019, first month of the new year, there were 264 notices of intent to sue under Prop 65. It is a very active litigation area. But we know that Prop 65 covers a whole myriad of various chemicals and compounds. So, what are the hot topics? Well, alcoholic beverages, surprisingly. And these are that is a result of modifications to the warning requirements that we're going to talk about a little bit later. Household products in big box and discount stores and their associated websites. Food products, marijuana, not surprisingly. Cosmetics, particularly skin lightening creams containing mercury. Plastics containing phthalates, and here, just so that you can understand the breadth of that issue, phthalates are what we put into plastics to make them flexible. And so almost all of the plastics that you come in contact with are likely to have phthalates present, and so this has become a large litigation area. And then there's always our favorite, which is lead, particularly lead in brass products. So going back just a little bit, stepping back just a little bit, in August of 2016, OHIA adopted amendments to the Prop 65 regulations, Article 6, concerning how we would define clear and reasonable warnings. Those were adopted in December 17. They became effective August of 18. And the new regulations, when they became effective, did two things. Under Article 6, sub-Article 1, the new regulations clarified what were the mandatory provisions for providing a clear and reasonable warning. What did you have to do? Article 6, sub-Article 2, which we're going to talk about much more today, is what you could do over and above sub-Article 1 to assure that your warnings fell within a safe harbor. What OHIA was saying effectively is, under Article 1, here are the minimums that you have to do. You don't have to use our specific warning language as provided in sub-Article 2, but if you use the language in sub-Article 2, you are presumptively safe. Under sub-Article 2, we had the consumer product warnings. And again, in our previous workshop, our previous webinar, we talked significantly about what that meant for consumer products. One of the key issues that came up was what was called the short form warning, a warning that did not require you to identify a specific Prop 65 compound for which the warning was being given. Since then, OHIA is reviewing if the short form warnings can satisfactorily meet the Prop 65 requirements. Because effectively what everybody did, if it was possible, is they said, why do I want to identify a specific compound if I don't have to? I'll just use the short form warning. And what OHIA is now saying is there's no guarantee that the short form warning will continue as a future compliance alternative in many cases. It is certainly a valid compliance alternative as of today. But OHIA gave us some insight into their thinking. When they created the short form warning, they intended it for small products or items that really had limited space to provide a warning on. However, there was no rule or no condition set as to what a small product or item was. And so it's currently generally applicable. I think OHIA is going to have to wrestle with, if you're going to limit the short form to small products, how the heck they're going to identify or define what a small product is. Take-home message for today, the short form warning continues to be a valid warning form. But we need to keep an eye on this because I think the OHIA may change or limit the application of that short form warning. Now we're going to get to sub-Article 2, where we have this whole series, and this is a terrible slide, but we have this whole series of specialized warnings that we're going to talk about in a great deal more detail, that if you choose to use the specific product warning content, you are within the safe harbor. The first one is something that's been out there for a while, which is the environmental exposure warning. That is, when do you have to give a warning for not so much a consumer product, but an exposure because an invitee, a person comes into an area that exposes them to some Prop 65 compound. Example might be that you have, I don't know, various kinds of chemicals in the carpets in your hotel, and those compounds are listed as Prop 65 compounds. You now need to give an environmental exposure warning. What I've given you on this particular slide is the various language alternatives that you can use. They always all start out with the caution symbol. You remember that. It's the yellow triangle with the black exclamation mark, the word warning, all in capital letters and bold, and then varying language depending on whether we're talking about a carcinogen, a mutagen, or both. The more important part of what we provide here in Art Subarticle 2 is then how do we give that warning? And there are three basic methods. For indoor environmental exposures or outdoor spaces, we can use a sign, but the sign must be no smaller than 72-point type. It must clearly identify the source. It must be provided in a conspicuous manner, and it must be provided not only in English, but in any other language in which other directional or signage is provided at the facility. The second alternative is a warning provided, notice or mail sent electronically. These are typically used where you have a short-term exposure. You're going to put asphalt on a road. You know the asphalt contains compounds known to the state of California to cause cancer and or reproductive harm. You know that there's going to be some emission of those chemicals in the local area. Well, you can provide a notice by mail to the homeowners or property owners along that portion of the road, hypothetically, that you are going to put asphalt on. Here, again, you must clearly identify one or more of the sources. You must include a map of the affected area. You have to provide this warning at least every 3 months. And again, it must be in multiple languages. The third alternative is warning by publication. That is, you're going to put a advertisement in the local paper of largest circulation, and it must be clearly, and it must be in essentially the front section or the business section. It has to clearly identify one or more of the sources. It must include a map. It must also be published in the electronic version of the publication, if there is one, and it must also be in multiple languages based on the population that is serviced by that publication. Okay, so now we've talked about consumers and we've talked about exposure at a particular location. The next class is occupational exposure warnings. Your employees. And here what Prop 65 says is there are two options. The first one is, look, if you are already providing a warning based on FIFRA, based on the California pesticide regulations, based on federal OSHA regulations to your employees, that is sufficient. But where those kinds of warnings are not being given, either because the compound in question isn't subject to federal or state warning regulations, then the warning has to be given, and it has to be consistent with the consumer environmental warnings provisions that we've talked about before. Food exposure. If you have a food product or a dietary supplement, the warning must be provided. It is, again, the same rules as consumer products in terms of the form of the warning. Can it be a short form warning? And most particularly, the need to provide that warning through any internet sales options that you might have. Alcoholic beverages. The new regulations break alcoholic beverages into three categories: package sales in bars, restaurants, and delivery services. Where you have sales through a packaged goods store or a bar, the language of the warning is given here in its very specific language. The warning method, again, there must be a signage of a given size, no smaller than 22-point type. The notice and sign may be no smaller than 5 by 5 inches. I'm not going to walk you through each of these components, but basically, and again, the warning must be provided in English and any other language used for labeling or advertising the product on the premises. Okay, I think this is going to be particularly challenging for packaged goods stores, where what's the neighborhood? Who do we service? What other languages other than English are commonly spoken, such that you are putting signs up in your store that say things like, we don't accept checks, whatever else. If you use a different language to notify the customer of some other labeling or advertising issues, you have to put this warning in those languages as well. Restaurants. We have a new set of warning language, and here the warning message has to be provided through the menu, through any list that identifies the alcoholic beverages. For instance, if there's a sign behind the bar that says, here are the 52 different beers that we're serving today, that message has to be with that signage. And again, the warning must be provided not only in English, but any other language. Delivery services, where the alcoholic beverage is being delivered, then again, we have specific language, but the warning here must be incorporated into the packaging and a type of size no smaller than the largest type size used for other consumer information on the product. You need to go back and look at what the definition of consumer information is. That doesn't necessarily include all the information on the label, but specific to where there is specific consumer information, the type size must be no smaller than that consumer information. In no case can the warning be less than 8-point type. It has to be readable and conspicuous to the recipient prior to the consumption of the alcoholic beverage. It's sort of like beauty in the eye of the beholder, but clearly you can't stick the warning on the bottom of the box or the bottom of the bottle. The warning must be provided in English again or any other language. And again, I think that's going to be a difficult challenge to determine what other languages are going to be necessary. Restaurant food and non-alcoholic beverage exposure. Now we're talking about not alcohol, but we're talking about McDonald's, or we're talking about your local donut store. And if you look at this language, it is really quite specific. They tell us certain foods and beverages sold or served here can expose you to chemicals, including acrylamide. Well, if you have any baked goods or fried materials, you will have acrylamide. So we're talking most fast food places, most bakeries. Frankly, if they serve you bread in the restaurant, the sign has to go up. Okay. They also reference mercury. That's a sort of hangover from seafoods. But I think the acrylamide component is really the tough one here. The warning method, again, 8.5 by 11-inch sign printed no smaller in this case than 28-point type. Okay, and it has to be conspicuous to customers as they enter each public entrance. So you are talking about a sign being posted at each entrance to your McDonald's. And how about the takeout window? Likely has to be posted there as well. Sign smaller than 5 by 5. The warning on a menu or list describing food or non-alcoholic beverage offerings in a type size no smaller than the largest type used for the names of general menu items. So if you've got a super burger in 20-point type, then the warning needs to be in 20-point type. And again, in all languages otherwise used in that particular restaurant or food service facility. I want to stop a minute. Remember, these are the safe harbor warnings. You are not absolutely required to use them. You can use something less than the safe harbor warning. But should you choose to do so under subarticle 1, the burden of the adequacy of that warning then falls to the defendant. So what subarticle 2, and we'll continue with these in a second, does is it tells us what we can do to make sure that we're not going to have to litigate over the content of the warning. Prescription drugs and emergency medical dental care. Okay, prescription drug labeling is as per FDA requirements. Where you do not have FDA requirements, then for exposures resulting from an emergency or urgent medical or dental care, we don't have to give a warning. Here's the difference. When we talk about an FDA prescription drug, that does not include over-the-counter. It doesn't include a device. So if you are I'll make up an easy one. If you are a user of a CPAP machine, a machine to help you breathe when you're sleeping, and you receive additional tubing for that machine, the question becomes, does it have to carry a Prop 65 warning? Well, it's not a FDA prescription drug, so I don't have that exception. And it certainly isn't resulting from emergency or urgent medical or dental care. Therefore, it is likely that that particular product or that device requires Prop 65 warnings. Dental care. Here, OHIA has gone and given us a specific language and specific postings for each dental office, stating that the procedures performed can expose, and then gives a whole list of those procedures that could include Prop 65 chemicals. And as I read that list, there isn't pretty much anything that you could do in a dental office, maybe other than a cleaning, that isn't covered by this. And then tells us that it has to be posted. The warning has to be posted at all public points of entry. It gives us a signage size, a type size, and again, it must be in the languages that are otherwise provided by that dental provider. The other alternative for dental care, however, is that the warning can be provided through an informed consent form signed by the patient prior to the exposure. And I suspect, other than posting signs, this will likely be the most common way in which the dental industry addresses this issue. Raw wood. First of all, what is raw wood? Well, OHIA says raw wood includes logs, saw lumber, plywood, composite wood panels, engineered structures, and similar wood products. So it pretty well covers the entire scope of anything made of wood. And we have a specific warning language about drilling, sawing, sanding, or machining. And then we are told that the warning is displayed either at the point of sale or display of the wood products, and it gives a sign and a point size. And where the product is sold in bulk form, the warning may be provided on an invoice. That is, if I call up the local lumber yard and say I need 50 2x4s 8 feet long, the warning can be provided through as part of the invoice. Furniture products. Apart from raw wood, we are now talking about furniture products. And this is particularly an issue for furniture products made of composite wood products, which are also regulated under TSCA, and we'll talk a little bit about that later. But this, again, we have specific language The warning has to be affixed to the furniture product in the same manner as any other consumer information or warning. And they tell us how big and what type size. Diesel engines are broken into three classes. Diesel engines that are not part of passenger vehicles or recreational vehicles, diesel engines that are in vehicles, passenger vehicles, and diesel engines associated with recreational vehicles, which when you take a look at the language, I think they intended to be for boats more than anything else. We have specific language about what the warning has to look like. We have specific language about where the warning has to be placed. It must be both in the owner's manual. It must be on the product per se. If there are other warnings placed on the product, which is going to be highly likely, hot, do not touch, whatever. And the warning must also be provided in an on-screen display if the engine comes with some on-screen display or control panel. For vehicles, and those of you who have bought a vehicle recently, I think you've seen these. The warning method includes it has to be in the owner's manual, and it has to be affixed to the front window of the driver's side of the passenger vehicle or off-road vehicle. If it doesn't have a passenger side, driver's side window, then you can hang it on the rear view mirror on the tag. That label does not need to be permanently affixed. But for all vehicles that are being sold, new or used, we now need to give this Prop 65 warning. And if you go into the large dealerships, at least in Southern California, you see these warnings being provided. There is some question, although I believe that even if you were involved in a private sale, this warning may very well be applicable. Recreational vehicles, the language changes somewhat. The concept is the same as cars. The only interesting thing that I find here is the language is clearly appears to be directed towards pleasure boats. Enclosed parking facilities. We have the warning provided for you. Here, the warning method, again, is provided, but the most important part of this warning that I'd like to highlight for you is that putting up this warning does not preempt your obligations for what might be other associated warnings, i.e., is there an environmental warning obligation because there's something more than just the carbon monoxide and gasoline and diesel exhaust from the cars? Is there something else present? Is this parking garage associated, and we're going to see this in a minute, with an amusement park? What kind of warning has to be given? The fact that you are warning about air in a closed parking garage does not preempt the obligation to provide all the other warnings that might be relevant to other activities associated with that parking garage. Here's a new one that we hadn't seen before: amusement parks. We are now obligated, or amusement parks are now obligated to give a warning. And again, I won't read it to you, and you can look at the language. But again, there is this caution that says not only do we have to give that warning at the entrance or where people are going to come in or where people have the most access, but the fact that providing this warning does not preempt the potential obligation to provide other warnings associated with enclosed parking, food, beverages, alcohol, whatever else that might be occurring on the premises of the amusement park. Disney is going to be so happy. Petroleum products other than service stations. This is a warning that's primarily focused on refineries, bulk transfer stations, etc. The language is the same as is given here. The method is the same as other environmental exposures. And again, it has to be given in multiple languages. If there are other signs at that facility in other languages. We now have a specific warning for service stations, and you can see that the language is specific to service stations. It is a warning provided by signage, and again, the warning has to be given in multiple languages. They have separated service stations, which I believe they have meant to define as places where one fuels one's car, from vehicle repair facilities. Vehicle repair facilities, again, you get some specific warning language that is focused on vehicle repair facilities. Again, it has to be 32-point type, posted at each public entrance, and again, in multiple languages, if multiple languages are used at that facility. Designated smoking areas, we've had this one for a while, but again, if you have a designated smoking area, here's the warning that needs to be provided. Biphenyl A. Now, this is a warning that's currently is disputed, has debated, has a sunset provision, but what we are really talking about is the use of biphenyl A for to line metal cans or metal caps for the food production. The warning language is provided. Again, the warning is to be provided at point of sale. It also must be provided if the product can be sold over the internet. But this is one warning that is still, the need to give this warning is still something of question. Failure to warn versus overwarning. We've talked about all of the safe harbors, but then the next question becomes, do I need to give a warning? OHIA says that all of these specific warnings and all this new guidance under Article 6 is intended to reduce overwarning, in which businesses provide unnecessary warnings for the content of a product rather than exposure to a chemical. The problem with that statement is that Prop 65 does not require testing to determine if a warning is necessary. So there's always the question, do I need to give the warning? Is one of the, 800 various Prop 65 compounds present? If it's present, is it present in a level high enough to exceed a safe harbor daily dose? Those are a lot of hard questions to answer. Meanwhile, there is no penalty for overwarning. There are significant penalties for failure to warn, both in terms of, you can see the volume of citizen suits that are out there, which is the primary enforcement vehicle. So our guidance is that when in doubt, a business has to balance the risk of failure to warn versus the cost and marketing impacts of overwarning. When do I decide, and how do I decide that, yes, I'm going to go through a rigorous evaluation of product X because putting a warning on product X will have a significant impact on its sales, or I'm going to reformulate product X so I don't have to give a warning because that warning will have a significant impact on product sales, versus, this is not, I don't think a warning is really required. It doesn't appear to have any of the hot chemicals in terms of things that are being sued over. How do I best use my resources to best put warnings, to implement my obligations to provide a warning or versus overwarning? Responsibility for providing the warning. OHIA now places the primary responsibility for providing the warnings on the product manufacturers, producers, packagers, importers, suppliers, or distributors. The intent was to try and reduce the burden on the retailer. And this is primarily for consumer warnings. There are some exceptions when the retailer does certain things, obscures the warning label, removes the warning label, received notice and warning materials and refuses to put them up. There are a whole series of things that, as the slide explains, that are exceptions. But generally speaking, the obligation to provide the warning is on the supply chain before it reaches the retailer. However, that liability can be contractually transferred. That is, the people in the supply chain can agree all the way down to and including the retail seller can agree who is going to take the burden to determine if a warning is required and then to provide a clear and reasonable warning. And what the regulations now say is that that agreement shall bind the parties to, and shall supersede the requirements of the regulations. That is, you can contractually allocate the liability. And in some cases, particularly in cases where you're a distributor or you are have a tangential role in the supply chain, you may really want to think about adding language. And maybe if you are a retailer, you may want to be thinking about adding language to your contract, to your purchase agreements that specifically allocate the liability so you don't have a debate later. And I say that for two reasons. We've seen this come up in two ways. One, the dispute between different people in the supply chain as to who had the responsibility. But two, then the issue that comes up where the citizen suit enforcer sues everybody in the supply chain. If we have a document that says, to the extent liability exists, it exists only for the consumer or for producer X, then we can simplify the litigation, which in turn reduces litigation costs. So over and above, we've now talked about Subarticle 1, Subarticle 2, special warnings, how we can allocate liability under the warning systems, et cetera. Now I'd like to take a few minutes and talk about some regulatory updates. The first one being some exemptions. I think you've all now heard that coffee has been defined to be the acrylamide in coffee is now been determined to be exempt from Prop 65 warnings. However, the state Supreme Court depublished an opinion in the cereal cases saying that baked goods, effectively the baked goods containing acrylamides, would also be exempt. So we're starting to see some exemptions coming that are not part of the safe use determination regime. And we ought to be looking at these as guidance for other compounds or for other industries as time goes on. New additions. I've given you 4 of the latest additions to the Prop 65 list. I give them to you just to give you some idea of the breadth of the kinds of things that are now going to require warnings. Dyes and antifungals, chemicals used for ejector seats in fighter planes, an approved alternative solvent that meets the strict requirements for VOC compounds. Yippee, it's good for greenhouse gases, but now will be listed as a Prop 65 compound. A anti-cancer drug that is used to treat colon cancer and non-small cell lung cancer, but now will have to carry a Prop 65 warning. Now, again, we know that because it is as an FDA-approved drug, it will not necessarily have the warning, but it's now listed as a Prop 65 compound. The other interesting one of the other interesting changes that has come up recently is some regulatory guidance on the calculation of reproductive toxicity for food products. How do you measure whether or not you have exceeded the daily dose threshold? And again, I'm not going to go into this in detail, but it talks about whether or not You can use multiple samples. If you can those multiple samples be from different facilities? Do you use the arithmetic mean or the geometric mean? Um, I not only I think is that right now this is a standard that's limited to food products. However, I think it will provide us with guidance as how to determine whether other products fall within the safe harbor. Much like we use the lead determination for fishing weights to look at lead exposures across a whole bunch of other categories. If Prop 65 wasn't enough, we now have in California the Safer Consumer Products Program. This is a scheme by which manufacturers are looking at designated product substances pairs. That is the use of a specific compound in a specific product and asking a question, is there an alternative or a safer replacement, and requiring the manufacturer to go through that alternatives analysis. Examples we have so far, children's foam padded sleeping products, methylene chloride in paint strippers, NPMP in paint and varnish strippers, toluene in nail products, spray polyurethane, PFAS. I won't even try it. Let's call them PFAS in carpets and rugs. PFAS are really becoming a significant issue, not just under this program, but also under the state water regulations, where they are looking at PFAS in terms of being a pollutant of concern in surface waters across the state. Laundry detergents with certain surfactants. I think that this list is going to continue and expand. How they determine which product substance pair should be on the list or how that is to be prioritized is still in some ways at issue. But clearly we now have, in addition to Prop 65, this new regulatory regime. Department of Pesticide Regulation, again, new regulatory regimes, particularly in terms of chlorophos. And we're not alone. The state of New York is now sort of following under what it calls its Consumer Right to Know Act, get a similar regime or moving into a very similar regime to the Prop 65 regulations in terms of providing labels and warnings. Now, right now, those labels and warnings are sort of limited to cleaning products and personal care products. But like any other regulation, it is likely that this will expand to other retail products. TSCA, I talked briefly about that before. TSCA Section 6 rules, we're going to start to see, much like the state safer products rule, this idea of restricting chemicals in specific applications where it determines there's an unreasonable risk to human health and the environment. The chemicals high on the list right now, as an example, are TCE and vapor degreasers and spot cleaners. Again, the question now becomes, how does that list grow? How does it expand? How will this list differ from the California state safer products list? We have yet to see, but we need to keep an eye on these in terms of how we develop, design new products and how we look at our existing product lines. Just for fun, amazingly, the Food and Drug Administration has determined that lead acetate is a bad thing for hair dyes. On the other side, we are seeing more and more companies creating restricted substances lists, Walgreens being one of the most recent. And again, we're seeing Walgreens looking at all of these various state and federal regulations. Prop 65, the toxics release inventory, cosmetics regulations, REACH, you name it, and saying, hey, we want to ensure that any of the products we are selling to our customers comply with these regulations through their restricted substances lists regimes. So I think we today have covered a pretty broad area. We started out talking about clear and reasonable warnings, subarticle 1, subarticle 2, the application of subarticle 2 to specific um, products or exposure scenarios. We looked at shifting the liability under Prop 65. We've looked at some other related regulations and how they might play together. And so that, and so I think we've covered a great deal of material, and we look forward to talking to you again.
Thanks a lot, Wayne. I just quickly want to reiterate that all of Wayne's slides and the entire webinar slide deck will be available to all registrants after the broadcast. So there was a lot of information that Wayne just shared, and just so you know, you'll be able to access that. And I'd like to now switch things over to Jennifer Kraus, who will be speaking to us about the different phases of Prop 65 compliance and some best practices around approaching the regulation as a whole.
Thanks for the introduction, Jay, and hello everyone and welcome. Today I'm going to be walking you through the Source Intelligence Proposition 65 process with respect to a specific type of warning, and that is on product labeling. I'm going to share some insight into best practices that we've seen here at Source, and then I'll touch on a broader topic that we've introduced over the past year, which is a hybrid approach to product compliance. So let me go ahead and jump in here. So here we have a pretty classic California Prop 65 workflow. So every product compliance program starts with a scoping process that defines which specific products are in scope for a particular regulation. And in this case, we're talking about California Proposition 65. Once you scope your products, you then contact suppliers relevant to the products to request information. Once you receive the information and the data, you'll analyze that, and then you'll make a labeling determination. It sounds pretty straightforward, but as many of you know, with any compliance program, whether it's product compliance or facility compliance, unforeseen challenges pop up at any phase. So what I'd like to do is for each one of these particular phases, I'm going to dive in and talk about them in a little bit more detail and then identify some best practices. So first, let's talk about product scoping. Product scoping is the practice of including or eliminating products from your Prop 65 program. So I think a good rule of thumb in product compliance is, at least one that I've used for the last several decades, is that it's better to be safe than sorry. If you're not sure whether your products contain regulated substances or what the potential exposure could be associated with those products, when in doubt, go ahead and include those products. Minimize your risk of non-compliance by conducting some sort of due diligence. And so here at Source Intelligence, we talk to a lot of companies who are stuck in this product scoping phase. So here are just some high-level scoping questions that you can use as a really good starting point with regard to scoping those products. So first off, let's talk about the regulation. Have there been any revisions to the California Prop 65 list since your last evaluation? As you know, new chemicals are being added on a regular basis. That list is typically updated a couple times a year. It depends. I think the last update was, I think it was March, actually, of this year. So, have there been any revisions since the last time you took a look at this? Did the latest regulation updates affect your product's compliance status based on substances that were added to that list if there was a change. What's changed in the regulation since the last Prop 65 evaluation? And in this particular case, labeling is one instance. So it's important to understand what has happened to the regulatory requirements since your last evaluation, or if this is your first time, obviously what those requirements are to begin with. A very basic question, of course, is whether the product is sold in the state of California. You'll also need to know the date the product was manufactured. Now, this is different from when that product is offered for purchase. So your product may have been manufactured in 2017, but not offered for sale, for purchase until 2019. So it's important to understand what that date of manufacture is for your product. Another question to ask as a starting point is, did any of your suppliers pass along compliance information that may have addressed Prop 65 in particular? So are there records or bills of lading and other documentation or information that may have been passed along from your suppliers that might help give you a little bit of insight into the Prop 65 applicability to your product? And frankly, another good thing to take a look at, obviously not rely on completely, but do your competitors have product labels on similar products? It's something you might want to take a look at to give you a sense whether this is something you need to be considering or not. And then obviously, if the ingredients in your product, the hazardous substances or materials, have they changed since your last Prop 65 evaluation? So these are all some early sort of high-level scoping questions that can serve as a really good starting point for you. So let's take a look and chat a little bit about data collection. Once you've got your official product count, you know what products are going to be in scope for purposes of your compliance program. Now it's time to collect data. So one of the things, obviously we're in the business of this, but we find that it's tremendously valuable whether you utilize Source Intelligence or another service provider, but having a centralized product database for product information is pretty critical for this step. The key to gathering robust product data is asking your suppliers the right questions. If you don't ask the right questions, you're not going to get the data and information that you need. So when requesting Proposition 65 information, provide your supplier with questions that will give you the data points needed for a comprehensive regulatory analysis. The correct data points are going to make all the difference in the world, and these are fundamental elements of compliance that we typically will focus on here at Source Intelligence. And with regard to data collection, one of the things that we've discovered is that sometimes using a full materials disclosure tool to collect data can pose quite a few challenges for many suppliers, and primarily because they just don't simply have that information. And if they don't have the information, it means they need to go to their suppliers and collect the information and so on. There are a few business sectors where we'll find that companies within those sectors, the electronics, for instance, and electrical equipment, are pretty comfortable with working with full materials, FMDs, full material disclosures, and bombs. But there are many other sectors that just aren't. So roadblocks like these are going to increase response times and potentially decrease your overall response rates, which in turn leads to risk associated with noncompliance. So if you're in a particular business sector where you're concerned that your suppliers are not going to be able to complete or properly complete an FMD, there are some alternative documents that you can request that will provide you with the data and information that you need, and that will offer up the chemical information related to Prop 65. And so some examples of that type of documentation are things like a certificate of compliance, which is pretty common, actually not just in the Prop 65 world, but in other product compliance requirements such as REACH and ROS. When we're collecting data out there for clients, certificates of compliance are pretty common. But you may also get lab test reports or QA documents and quality reports, which can also provide you with the chemical substance information that you're looking for. Manufacturing contract agreements can also be useful in terms of helping you gather the data that you need. Other things such as safety data sheets or product spec sheets can be useful. And even if you've got some exposure testing reports, or if you've had some industrial hygiene work done, that might be another place that you could look for information. So all of these types of documents or reports are pretty good alternatives to having to rely on an FMD for collecting data. So you've collected your data. Let's talk about product analysis, because I mentioned data centralization a minute ago, but product analysis is really where data centralization is critical. Analyzing products to see if one of over the let's see, I think the list is about 850-ish or so chemicals now on the Prop 65 list. Analyzing products to see if one of those chemicals is present in any of your products, and determining if the level of exposure exceeds the safe harbor level can be pretty time consuming, require a lot of resources. It can be, the process can be pretty meticulous. So centralized product information is going to make this analysis, possible to begin with, but more feasible as well. So at Source Intelligence, we use features such as tagging and other options to help associate a particular supplier or product and component to a regulation. When I say tagging, it's things like being able to tag a particular part, component, or product with a category or classification that is meaningful to your business or to your company. So it could be a business unit, for instance, or you may be able to tag parts and components based on product categories, based on geolocation of particular facilities or even of particular suppliers. So tagging is one of our fundamental features that helps our clients organize global supply chain data. Now, once you've got all of that information in front of you, now it's time to identify any Prop 65 naturally occurring or synthetic chemicals, checking their safe harbor levels, and depending on the level of exposure, providing a warning for those exposures. These are all the different types of elements that we help our clients with. So obviously, we're here to help. If you need assistance, give us a call, chat, email. So let me move on to the labeling decision. So as Maine mentioned a minute ago, there are differences between a Prop 65 warning and a Prop 65 label. The product label is an option of one of the methods that can be selected to provide the required warning. And the primary responsibility for providing warnings is placed on the product manufacturers, producers, packagers, importers, suppliers, and or distributors. So let's take a moment here to go over labeling. Every company approaches Prop 65 labeling differently. And I mentioned your business culture a minute ago. It really depends on your company's business approach and how risk adverse you are. Some companies are, I just want to check the box. I want to do the minimal. I'm short on resources. I want to comply, but I just want to check the box. Whereas other companies are more interested in, taking a deeper dive into the regulatory requirements and engaging in some really detailed, thorough due diligence to assess the right way to comply. And then there are others that are in between. So it's not that any of those are right or wrong, obviously, as long as you're choosing to comply, but it really sort of depends on your own particular company. So if I will add, if you are sort of on the, we're willing to assume high levels of risk spectrum, I just want to check the box. There are a couple of stats that I thought I'd share with you today based on just looking at the some of the data the other day. In 2018, there were just over 300 California Prop 65 settlements that totaled approximately $34 million in payouts. So that's pretty significant. The average settlement was about $40,000. So those dollar numbers are pretty high. And the intent here is not, shock value or anything like that. But what those statistics tell me is that Prop 65 is one of the most active regulations that companies face here in the United States. So while ultimately it's your decision whether to label or not, but as one of the leaders in the compliance services industry, I would certainly encourage you to do your due diligence. Also keep these few things in mind when you're discussing your labeling strategy. One is, what type of label are you going to select for your product? Are you going to use a short form, or are you going to use the long form? Wayne just talked about those a while ago. So think about whether you're going to be using the short form or the long form. And remember, one of the concerns with the short form is that its intended use is being overused or abused. So, think carefully about what approach you want to take. Again, there's no right or wrong, but just think carefully about what you choose and why you choose it, and document what you've done. Because these warning labels have very strict requirements that have to be followed, everything from font size to where the warning symbol should be placed, etc. So you can't just slap any old warning on there, and you'll notice that. That's why there's some consistency in the warning labels that you'll see today, whether you're purchasing something over the internet or pumping gas in your car. So the other thing you'll need to think about when making a labeling decision is, what is the main chemical that you are choosing to disclose? If there's only one listed chemical in your product, that makes it easy. But if you have several, you'll need to think about which ones you want to choose. And then, what is the associated warning for that chemical? Does it cause reproductive harm? Is it cancer causing, or is it both? And that's another thing that you'll have to think about. The other thing too is, take a look at your product, and is it going through any new and improved model evaluations? Are you changing the branding of that product, which could also sort of, is it a new and improved? That could also lead to perhaps some formulation changes, where you might simply want to choose an alternative material that could change your Prop 65 labeling needs. So those are other options that you'll want to consider when thinking about on product labeling. So just to quickly add, we do have a labeling program here at Source Intelligence. We can advise you on the label you'll need and what the contents of that label should be, and it'll be based on the data that we go out and collect for you. So anyhow, so let me just move into my last slide, and that is to chat a little bit about what we call here a concept that we've developed here called hybrid product compliance. The California Prop 65 program process options I just walked you through are ways of approaching product compliance in a methodical and resource efficient way. We've been able to successfully apply this type of process flow to both the REACH and ROS regulations, as many of the products' data points overlap and can be leveraged across different programs like our combined products regulations program. So many companies who work with us to gather data on Prop 65, while we're collecting that data, we might as well assess whether they are REACH and ROS compliant as well. So rather than going through the resource-intensive process of requesting supplier data on all three regulations separately, we've designed a program that allows suppliers to submit product data relevant to all three regulations at one time, thereby sort of consolidating the product compliance efforts, minimizing the number of times that you go out and request data and information from your suppliers, which reduces their survey fatigue, so to speak. And we've seen that using this approach, we've seen cost-effective benefits such as increased supplier response rates, less supplier fatigue, as I just mentioned, and really just an overall increased supplier engagement, which has its benefits in and of itself, particularly the improving the accuracy of the data that you're collecting, as well as the timeliness too. So there's two elements of the hybrid product compliance process that changed the Prop 65 compliance process I described earlier. And one is product scoping, and the other is a regulatory requirement assessment. So with regard to product scoping, instead of only looking at products that you sell in California, your scope would open up to products in the EU that are in scope of the REACH and ROS regulations, which would make sense. Or, any other, let's say, U.S. state-specific product compliance regulatory requirement. So in the scoping, you'll need to consider what regulatory requirements are applicable in this particular case. And then instead of looking at whether or not to label, you would just apply the data or documentation you've collected to satisfy with the requirements for REACH and ROS regulations. So you're just expanding the breadth, so to speak, of that regulatory requirement assessment. So anyhow, that is all I had for today. I am going to turn it back over to you, Jay. But again, if you've got any questions, I think we've got, Jay will put up on the screen shortly ways for you to get in touch with us. And we'd be happy to answer those questions and help you out. Okay, thanks very much.
Thanks, Jennifer. Yes, so as Jennifer mentioned, I'd just like to quickly give you guys a few resources here as we move on from today's webinar session. First off, make sure you subscribe to our blog. We're always coming out with thought leadership pieces, information around regulatory updates, and best tips and tricks for approaching compliance with all the different regulations that we work with. You can also watch an additional webinar, or you can also grab a white paper. We have a full library of white papers. And lastly, if you guys have any particular questions or challenges that you're facing at your company, or you'd like to learn more about the advantages of platform-based compliance, please feel free to reach out to us. We're happy to help in any way. So thank you very much for your guys' time today. That's all that we have for you today. And please be on the lookout for the follow-up information. Thank you guys very much and have a great day.